Welcome to the presentation, Parents' Guide to Their Procedural Safeguards. Thank you for the opportunity to join you in celebrating Neurodiversity Week. My name is Lisa Melbreck. As you can see, before founding Kids First Advocacy, I spent 18 years as a trial paralegal. And it was my own experience navigating the special education system for my two neurodiverse children that led me to become an educational advocate. I hold degrees in psychology and speech communication and a master's in communication management from the University of Denver, along with specialized training through COPA and Rights Law. Today, I hope to share some of what I've learned along the way. When it comes to special education, I always start with the law. When you look at 34 CFR 300, federal regulation under IDEA, it specifically addresses the requirement that schools provide parents with a procedural safeguards notice. This is what the current Colorado version looks like. Some districts are still using an older version, so make sure they provide you with the April 2024 edition that looks like this. IDEA protects the rights of students with disabilities and their parents. One of the most important ways it does that is by giving parents the right to meaningfully participate in developing their child's special education program. So this guide tells you about those rights. Your procedural safeguards booklet is 47 pages long. 30 pages of main content. So today we're going to be strategic about where we start. The later sections, parts B and C, address your rights when disputes arise, and those matter enormously. But we're starting at the foundation, the introduction and part A, which cover why these safeguards exist and your rights as an everyday participant in your child's education. If you understand these, you're already ahead of most parents walking into an IEP meeting. So let me ask you something. When those pages are handed out at the beginning of the meeting, do you actually understand what they mean? For those of you following along at home, we're starting on page 1 under the introduction. So I want to set the stage with a real scenario from one of my meetings. You've arrived on time. The meeting hasn't quite started. Someone's getting coffee. Someone's troubleshooting for another attendee who's joining virtually. You sit down across from 4 people with school lanyards. The special education teacher, your child's case manager, picks up the 47-page guide and smiles. I'm required to give you your procedural safeguards. You probably already have 100 copies and are using them as wallpaper by now, she says. A few people smile. Someone laughs. Do you want another copy? No? Okay. Just sign that I gave them to you. She's already moving on. You sign. Everyone moves on. It is very difficult in that moment to be the person who says, actually, I'd like to understand what I'm signing, please. Their humor isn't malicious. That's exactly what makes it effective. It turns a legal handoff into a social moment. And in social moments, asking questions feel like being difficult. She was technically right. She gave them to you. You signed. Box checked. What she didn't say, this document contained your right to file a state complaint, and that 1-year clock is already running. Your right to request an independent education evaluation at public expense is in here. Most parents never find it. The wallpaper joke made all of that feel like it was beside the point. IDEA requires schools to provide families with procedural safeguards because parents and school systems do not come to the IEP table as equal participants. Schools work inside the system every day. They should know the timelines, the terminology, and the assessments. And when they don't, that's often where the trouble in a meeting starts. Parents are on the outside looking in, often learning the system and trying to remember every acronym while supporting a child who's already 2 grade levels behind or struggling with behavior in the classroom. Procedural safeguards exist to balance that reality. They outline the rights families have and the options available when a team cannot agree on what a child needs. These safeguards are designed to protect your participation. Your school district is required to give you a copy of this guide at least once every year. Most districts send it electronically with IEP paperwork and have a physical copy at every meeting. But required and actually understood are 2 very different things. That's what this presentation is all about. So if you're following along, we're at the bottom of page 1. Before the school can evaluate your child, start services, conduct an FBA, or change placement, they need your written permission. Informed parental consent. In Colorado, the FBA, Functional Behavior Analysis, requirement is specifically called out, which matters because FBAs often come up in disciplinary situations. Informed consent means more than signing a form. You have to understand what you're agreeing to, and no one can pressure you into signing. Consent is not required when the school reviews existing information or administers assessments given to all students. You can change your mind, but it has to be in writing. Once you withdraw, services stop, and the school issues a prior written notice. And here's the critical piece. Withdrawing consent does not undo what has already happened. You cannot unwind the past. That goes for evaluations too. Withdrawing consent for an evaluation can limit your legal options later. Think carefully and talk to an advocate first. Last thing, if the school made reasonable efforts to get your consent for a reevaluation and you didn't respond, they can proceed without it. Don't ignore consent forms. Respond even if your answer is no. If you're following along, we're toward the bottom of page 3 now, and this one often gets missed. Native language and other modes of communication. This applies to 2 groups of people in this room: parents whose native language is not English, and students who need to be assessed in a language other than English. For parents, the school district is required to ensure that you can actually understand what's happening with your child's education. IEP meetings, evaluations, and all notices must be in your native language or the communication mode that you use. If you're deaf or your native language is not English, the district must arrange for an interpreter at the IEP meeting. The final IEP must be translated or recorded in your language so you can understand what services are being offered and track them throughout the year. For students, evaluations must be conducted in your child's native language or mode of communication. If you are testing a child in a language they don't fully understand, the results don't accurately reflect what that child knows and can do academically, developmentally, or functionally. The law recognizes that and requires that tests and materials be in your child's language, unless it's clearly not feasible. In the Colorado-specific piece, if your child has been identified as a multilingual learner, Colorado law requires the district to offer translation of the final IEP, written or oral, in your dominant language. They must also verbally tell you that you have the right to request that translation. If no one has ever told you that, now you know. Heading on to page 4, is your child eligible for special education? This is a pretty big question. To be considered a student with a disability under IDEA, your child must require special education due to their disability in one or more of the following categories. Colorado recognizes 13 eligibility categories, each with its own set of criteria. You can find them in Appendix A of the full guide on the Colorado Department of Education website or under resources at my website, kidsfirstadvocacy.com. Specific learning disability includes 8 areas: basic reading skills, reading comprehension and reading fluency, written expression, mathematical problem solving, and mathematical calculation, as well as oral expression and listening comprehension. If they've qualified for one of those areas, they've qualified with a specific learning disability. Developmental delay has a star next to it because eligibility under this category is only available through age 8. Once a student turns 9, they will need to qualify under a different category to continue to receive special education services. But eligible means 2 things have to be true. Your child has a qualifying disability, and that disability impacts their learning in a way that requires special education beyond general education. A medical diagnosis alone does not make a child eligible under IDEA. This is one of the most contested areas families run into, especially with autism spectrum disorder and ADHD. Schools sometimes take the position that a diagnosis doesn't automatically demonstrate educational impact. That's where families often hit a wall. Every child has a unique profile and is entitled to be evaluated individually, which is exactly why the evaluation process matters. And while we're talking about medical documentation, a doctor's note or diagnosis report is not a referral for special education evaluation. Schools sometimes treat it as though it triggers something automatically. It doesn't. The formal evaluation process has to be initiated separately, either by you in writing or by the district. The school is also not bound by a doctor's recommendations. A pediatrician writing, "This child needs an IEP," or "this child needs a paraprofessional," carries no legal weight under IDEA. The IEP team, not the doctor, determines eligibility and services. A lot of parents are blindsided by that. That said, medical records absolutely can and should be submitted for the team to consider as parent input. Diagnostic reports, neuropsychological evaluations, and physician letters, these are legitimate supporting documentation that the IEP team is required to consider. There's an important difference between "this diagnosis doesn't automatically qualify your child" and "this information is irrelevant." It's not irrelevant. Make sure it's in the record. Either you or the district can request an evaluation at any time. The district must respond with a prior written notice within a reasonable time, whether they agree to evaluate or refuse. Once you give consent, the initial evaluation must be completed within 60 calendar days. After a student qualifies, they must be reevaluated at least every 3 years or sooner if you request it. And you also have the right to refuse consent for reevaluation. Right now we're at the bottom of page 5, independent educational evaluations. As a parent, you have the right to request that the school district pay for an independent educational evaluation, an IEE, if you disagree with their evaluation of your child. You do not have to explain why you disagree. The district may ask, but they cannot require an explanation as a condition of processing your request. I want to be direct about this. Some districts have created their own IEE request forms that state you must provide certain information before they'll process the request. That is incorrect and misleading. All you need to say in writing is that you disagree with their evaluation. I recommend you keep it exactly that simple. The key rules for an IEE. So you are entitled to one IEE at district expense for each district evaluation you disagree with. The outside evaluator cannot work for your child's school district. The district must apply the same criteria to an IEE as it uses for its own evaluations. The district cannot simply refuse your request. They must either agree to fund the IEE or file for due process to defend their own evaluation. You may also obtain an IEE at your own expense at any time. Regarding cost, the district may set a cost cap, but that cap cannot prevent you from actually obtaining an IEE. If qualified evaluators in your area charge more than the cap, you have the right to explain those circumstances. Once an IEE is completed, regardless of who paid for it, the IEP team is required to consider the results when determining your child's eligibility and how to provide a free, appropriate public education. I just want to be clear that this is also to consider your child's eligibility. So to consider it, not ignore it. There is a difference. We're on page 7, prior written notice. PWN is also the acronym for this. It's a written notice the school district must send you anytime it proposes or refuses to take any action related to your child's education. Let me walk you through a scenario I see regularly. Your child has been having extreme behaviors at school, so disruptive that the school has called you repeatedly to pick them up early. You ask the school to conduct a functional behavior assessment to determine whether there's a pattern. Scenario A, where the school agrees. The PWN should tell you what they propose to do and why, what other options were considered, and why they were rejected, and what sources they used to make the decision. In this case, the parent report, the teacher input, and the discipline records. That's a compliant PWN. Scenario B, the school refuses. Their position, the behaviors aren't that bad, just something every now and again. Their PWN should still meet the same standard. What they're refusing to do, why, what alternatives they considered, and why those were rejected. In this case, they're saying existing classroom strategies are sufficient. So here's why scenario B is a problem. You have documented evidence that the behavior is impairing your child's education. The school has repeatedly called you to pick up your child. That's not every now and again. That's a pattern, and it's on your phone log. Also note that every time you pick up your child early in the school day, that's a suspension. It's not, and it should be labeled as such, signed paperwork, things of that nature. Call ahead of time to make sure that they have the paperwork ready for you to sign if you have to go in and pick your child up early. IDEA does not require behaviors to be severe for this. It requires them to be impeding the child's learning or the learning of others. Repeated removal from school easily clears that bar. A refusal to evaluate is a PWN, triggering event. If the district's PWN doesn't hold up to scrutiny, that's the foundation of a state complaint or due process claim. Your next move is to put your request in writing, if you haven't already, and start documenting every call, every early pickup, every incident report. That paper trail becomes the evidence that contradicts every now and again. One last thing about PWN and I say this at every presentation I give, this is the most underused section of the entire IEP, and it is rarely filled out correctly. So pull out your child's IEP after this presentation and find the PWN section. It's towards the end. Compare what's there against what you just heard. You may be surprised. Go with the check marks. Make sure you're looking at what exactly is the school doing or not doing, the action proposed or refused. Secondly, why the school is taking that action. The reasoning behind this decision, not just a conclusion. 3, other options considered. What alternatives did the team look at before deciding? 4, why those options were rejected. These need to be specific, not just we ran out of time or because. 5, the evaluation procedures or assessments used, what data or tests informed the decision. And lastly, the sources of information used, the reports, the observations, the records. What did they actually rely on for their proposal or refusal? Again, this is the most underused section of the IEP that I see. We're at the bottom of page 8, education records. So if you're having a difficult time with your school district or your child has been receiving special education services for some time, I strongly recommend submitting a FERPA records request. FERPA is the Family Educational Rights and Privacy Act. It's the federal law that gives you the right to access your child's educational records whenever you want. What's included? Any record directly related to your child that is maintained by the school district or anyone acting on its behalf. That includes IEPs, evaluations, progress notes, emails about your child, discipline records, and more. Don't forget the principal's file and the nurse's file. Those are 2 commonly missed areas that may contain some interesting information. Districts sometimes call this personally identifiable information, or PII. If it's about your child and the school has it, you are generally entitled to see it. A note on emails. Any email that contains your child's personally identifiable information is an education record under FERPA. That includes emails between staff, emails to and from parents, and any other correspondence that directly relates to your child. Most districts will not provide them under a FERPA request and will tell you they must be requested through CORA, the Colorado Open Records Act. That is incorrect. Know that going in, because you will likely have to hold your ground on it. CORA requests, Colorado Open Records Acts. If you look them up through your district, those cost quite a bit of money. The first hour they say is free. However, any other time spent is around $41 an hour. This they use to redact anyone else's information, any other student's information, things of that nature. But what they have taken away from this is that parents are no longer able to obtain those emails, even though they have personally identifiable information about their child. Only select few districts will provide those through FERPA. Otherwise, the other districts really hold their ground when they say that they are not maintained by the district. The other thing I want to make note of is instant messaging, or what might be considered in your child's school class dojo or talking points. This is a new area for FERPA. Not every district will retain those messages. So double check with your school and with your district of what they use. Most recently, a district said that they don't use Class Dojo or hold those records, but they do talking points. What was interesting is that the school used both. So when the parent wanted to request their child's educational records, their teacher used Class Dojo, which they just somehow got deleted. So make sure going in that you know what your school is using, what the district is using, and then request accordingly. And how to submit your request. So check your district's website for specific instructions. Some districts have an online portal. Others require a written request sent to the principal and the special education director. Follow their process exactly, because if you don't, they may push back on the request or delay it. The district for Colorado has 45 calendar days to respond. But if you have a meeting coming up, request the records far enough in advance to actually review them before you sit down at the table. This might be 2 weeks prior to the meeting. You want to make sure that you have your child's educational records. Send in the request, let them know the date of it and when you want them by. They may push back, but let them know that you are able to obtain those records prior to the meeting date. So that brings us to the bottom of page 10 and the start of section C, your right to challenge decisions made about your child's special education program through dispute resolution. We're not going to cover this section in depth today. That's a full presentation on its own. But I want you to know it does exist and what it covers and why it matters. Section C covers 3 formal pathways available. Section C covers 3 formal pathways available to you when you and the district cannot reach agreement: state complaints, mediation, and due process hearings. Each one has its own process, its own timeline, and its own strategic considerations. If you're currently in a situation where informal resolution isn't working, this is where you need to focus next. It's exactly the kind of situation where having an advocate in your corner makes a difference. So today we covered the foundation in our introduction and our parts B. Section C is where the foundation does get used. Section D begins on page 27, your right to challenge decisions related to discipline. Again, we're not going to cover this in depth today, but I want you to know it exists because discipline is one of the areas where families are most vulnerable and least informed. Section D addresses what happens when a student with a disability is suspended, expelled, or removed from their educational placement for behavioral reasons. Your child has specific protections under IDEA that general education students do not have, including the right to a manifestation determination review, which examines whether the behavior that led to discipline was a manifestation of your child's disability. These protections matter enormously, and the timelines are short. If your child is facing disciplinary action, do not wait to get help. So section C and D together are where the stakes get highest. Today was the foundation. Those sections are where you go when the foundation has been ignored. So part of my advocacy training was completed through Wright's Law with the amazing Pete Wright. If there is one takeaway from today, it is this: put everything in writing. As Pete says, if it was not in writing, it was not said. If it was not in writing, it did not happen. If the school or district calls you to discuss your child, follow up with an email. If you suspect bullying, put it in an email. If your child had a rough morning, give their teacher a heads up by email. Communication is key, and a paper trail is protection. So thank you so much for spending your morning with me. This information belongs to every family navigating the special education system, and the fact that you're here today means you're already taking it seriously. I am happy to take